Greetings, my fellow freedom-loving thinkers. Thank you for tuning to LL3-Podcast. My name is Craig, transmitting from the beautiful realms of planet Earth. Today's date is Monday, September 8th, 2025. This is episode 1892. The SCOTUS fight over copyright claims and Ammon Bundy slams FBI awarded agents. Before I proceed, you can find me on multiple social media sites and podcast channels. Just type in Lucky Luck number 3, Lucky Luck Roman number 3 with 3 eyes, or the Lucky Luck Roman number 3 podcast. In addition, if you have any questions, comments, recommendations, and all that good stuff, whatever you do, please use decorum. Hit me via email to ll3.podcast at proton.me if you're donating to PayPal.me or Cash.app /Lucky Luck number 3. If you want to give me a little crypto love or be a disciple on Steemit, I'm at LL number 3-podcast. Oh, man. Well, I'm just going to start by reading this first article. Came from reclaimtheinternet.org. It's in reference to the Cox versus Sony Supreme Court ISIP copyright liability free speech, you call it. So, came out today. Supreme Court fight that could decide who gets to stay online. Tech giants and civil liberties groups are urging the court to reject a ruling that weaponizes copyright law against everyday internet users. This is by Dan Freeth. As it reads, a lineup of civil liberties organizations, technology companies, and internet freedom advocates has filed a brief supporting Cox Communications in a closely watched Supreme Court case that could dramatically alter how internet service providers respond to copyright complaints. The case, Cox Communications versus Sony Music Entertainment, asks whether ISPs must terminate internet service to users accused but not convicted of privacy. Interesting. So, guilty till proven innocent. Guilty and just at will. Now continue on. The Supreme Court's upcoming decision is one of the most consequential internet-related cases in years, not just for copyright law, but for the future of how people access the internet in the United States. At stake is a fundamental question: can internet service providers be held liable to forced to cut off internet access to users simply because they've been accused of copyright infringement without any judicial process or proof? Those staying with Cox include the Electronic Frontier Foundation, American Civil Liberties Union, Google, Amazon, Microsoft, Mozilla, Pinterest, and X. Interesting. Google, Amazon, and Microsoft are all on the same team. Interesting. But I'll continue on. Kiwi Farms founder and president of U.S. Internet Preservation Society, Joshua Moon, also filed a brief in support of neither party, but opposing internet cutoffs and arguing that contributory copyright infringement is a judge-made doctrine without a statutory basis, and it has become unworkable and unfair because courts have never clearly defined its knowledge standard. This vagueness, combined with the rise of the DMCA's notice and takedown regime, has chilled free speech and fair use, extended copyright monopolies, and produced abusive practices. Cox argued that the Fourth Circuit ruling, which held it liable for contributory infringement and ordered a new damages trial, create an untenable standard that would force ISPs to police user activity under the threat of billion-dollar judgments. In a joint brief, the Electronic Frontier Foundation, American Library Association, and others sharply criticized the Fourth Circuit's interpretation. The Electronic Frontier Foundation, American Library Association, and other groups filed a joint amicus brief urging the court to reject the liability framework adopted by the Fourth Circuit. They argue that the ruling could lead to widespread loss of internet access based on unproven accusations with disproportionate consequences for ordinary people. The brief stresses the importance of online access in modern life, stating Internet access is essential to participation in economic, cultural, and social activity. The groups cautioned that adopting a liability standard based on mere knowledge rather than intent or inducement would cause serious collateral harm. The brief warns that imposing such rules on ISPs would inevitably result in users being disconnected because someone else in their household or workplace was accused of infringement. They further argued that the Fourth Circuit decision improperly expands secondary copyright liability without congressional authorization, threatening to undermine constitutional protections tied to access, communication, and expression. Even the U.S. Department of Justice weighed in, siding with Cox on key legal issues. The DOJ told the courts that the Fourth Circuit approach cannot be reconciled with the court's precedent and warned against punishing providers who may simply be indifferent but not complicit. In his brief, the DOJ stressed the evidence demonstrated at most that Cox was indifferent to his subscribers' infringement, not that Cox intended to participate in that infringement or wished to bring it about. On the issue of the willful infringement, the DOJ added that willfulness in the civil context generally requires knowledge or reckless disregard of the fact that one's own conduct is unlawful, not just knowledge of someone else's actions. A coalition of major tech companies, Google, Amazon, Microsoft, Mozilla, and Pinterest, also submitted a unified brief opposing the lower court's interpretation of contributory liability. They argue that the DMCA already outlines specific safe harbor rules, and the Fourth Circuit's ruling improperly weaponizes the absence of safe harbor protection. The Fourth Circuit ruling erroneously turns Congress's DMCA safe harbors into a liability-created mechanism, the company stated. They argue that liability should only attach to those engaged in conscious culpable conduct substantially assisting the primary wrongdoer. The brief makes it clear that a finding of willfulness demands more than simple awareness. Willfulness turns on the defendant's mental state regarding its own conduct. U.S. IPS criticized the legal foundation of the lower court's ruling as illegitimate and warned that fear of liability is driving ISPs towards censorship. The brief offers a critique of how the DMCA is more from the legislative compromise into a de facto tool of censorship. According to the authors, the number of such takedown notices are staggering, and the sheer volume further underscores the fact that there cannot be any meaningful review of material subject to a takedown notice to check for such niceties as fair use or prior authorization. They warn that lower courts have decided that the mere receipt of a DMCA takedown notice nevertheless gives rise to contributory copyright liability, a legal shift that discourages due process and chills lawful speech. The brief also highlights how automated systems have enabled bad actors to weaponize copyright claims against dissent and criticism. Takedown notices are increasingly being used for purely abusive purposes to remove political advertisement, satire, performance art, and online information important to virtually all aspects of modern life, it states. In an especially concerning precedent, the 10th Circuit held that simply reposting a takedown notice itself is evidence of contributory infringement liability, further entrenching legal risk for those who speak out. The outcome of this case could ripple across every household, library, and small business in the country. If the Supreme Court affirms the Fourth Circuit's reasoning, ISPs might be pressured to disconnect users as they receive infringement claims without waiting for any court to confirm wrongdoing. Interesting. It's funny because sometimes I see some flip-flopping too, even from Google, with all due respect. People have been censored online at will. Now they want to make a claim to be against it from Sony. Well, truth of the matter is, this whole thing at will is a sham, deceptive, and it does violate due process, even on the civil matter. They have to back up their claims and their facts instead of doing things instantaneously. That's what, based on this article, is all about. I have to agree with the petitioners on this matter to renounce the decision from the Fourth Circuit's reasoning. And don't get me wrong, if they blatantly violate copyright infringement, they got to take it to the courts, back up their facts, access, all that good stuff, licenses and all that. Then they may have a case. But if they're going to do anything in sight, including fair use, under the fair use, abusing the fair use laws or bypass that, that's when it gets very dangerous, and they can just do anyone at will. It could be like he said, she said. A little kids, oh yeah, like a little kid like snitching. Or talking, okay, they're guilty. That's they're going to play a little child's game. Romper Room 101. Well, one thing I know for sure, this needs to be renounced. And hopefully, the SCOTUS will prevail that petition. And I'm going to do my final segment right after this, so stay tuned. All right, I'm back. I'm going to do one more here. This came from the IdahoStatesman.com. Came out yesterday, but got updated today. FBI awarded agents for Oregon Standoff Bravery. Ammon Bundy says it's based on lies. And the person who wrote this, if I'm correct, is Nicole Blanchard. All right. So what bit Blanchard have to say about this? Yep, got updated today. It says here, key takeaways. FBI awarded Bravery medals to 4 agents involved in the 2016 Oregon standoff. Bundy family's disputes FBI account citing DOJ probe and aerial footage evidence. Attributed bullet in Ryan Bundy's arm could raise new questions, family claims. Ammon Bundy, a far-right activist who left Idaho in 2023 after a contentious court case ordering him to pay millions to St. Luke's health system, has taken issue with the FBI's decision to award agents who were involved in the shooting death of a man who occupied an Eastern Oregon wildlife refuge alongside Bundy in 2016. This is interesting because, like I said, far-right activist. Woo! The paradigm rhetoric, right? I'll continue on. In a statement to the media, Bundy's family contended that the narrative shared in an apparent FBI document included mostly false information about the fatal shooting of Arizona rancher Robert Lavoy Finicum by Oregon State Police on January 26, 2016. Here's what we know about what happened that day. Bundy's account, Finicum shooting aligns with reports. The Bundy family statement included a photo of FBI Director Kash Patel standing with 4 men with an FBI Shield of Bravery award displayed in front of them. Those men included FBI agents Joseph Astateria and John Neidhart. Excuse me. The photo was published in the Oregonian, which said a source shared it from an internal FBI document. The image includes a caption attributed to the FBI describing the agency's version of the shooting and its justification for honoring the agents. Okay, so interesting there. Okay, so the more red flags around Kash Patel, all right? Yeah, believe the hype, Oh, I'm laughing because it's pretty disturbing, too. It's like when Bill Barr praised the men that did that standoff at Ruby Ridge, and of course what happened at the ATF. They praised those people. What happened at Waco, the Waco massacre, many of us call it. I'll continue on. The caption states that the FBI's hostage team responded to the militia group's armed takeover by staging a traffic stop to arrest group's leader and key members outside the refuge, where the members planned to meet clandestinely. The caption continued to say that the militia leader trapped Nieder under the leader's vehicle and that other FBI agents freed Nieder as the leaders attempted to fire at Oregon State police officers and was finally shot. What? Not according to the video I've seen from the Oregonian. Wow. I'll continue on. The Bundy's rebuttal more closely matches news reporting and the Department of Justice investigating of the shooting. The Bundy statement said Finicum did not ram a law enforcement vehicle, pin a special agent, or attempted to shoot Oregon State Police. Aerial FBI footage of the incident and a Department of Justice investigation concluded that Finicum's truck swerved into a snowbank and not hit law enforcement vehicles that were blocking the road. That is a fact. I've seen the video myself from the Oregonian. According to reporting from the Oregonian, Nieder was thrown from a ladder he was using to see over the FBI's truck and ended up in the snow near one of the rear tires of Finicum's truck. Reports didn't show that he was hit by or pinned under the vehicle. I'll continue on. The final claim has been the most contentious piece of Finicum's death. Whether he intended to harm law enforcement, officers said, and video showed the rancher moved his hands into his jacket after exiting his truck immediately following the crash. The Oregon State police officer said they shot Finicum when he refused to comply with orders to get on the ground, according to the DOJ investigation. So they shot him for not complying. Okay, so that don't make any sense at all. But I'll continue on. Well, of course, he had his hands into his jacket. Well, it's cold out there. Go figure. Good grief. I'll continue on. Investigators later found a loaded handgun in the left interior pocket of his jacket. According to the Deschutes County Sheriff's Office, he was reportedly known to law enforcement to wear a shoulder holster on the left side of his body. The OSP... hold on here. I guess I goofed up. Okay, cool. The OSP admitted shooting him 3 times when he lowered his arms, but there is absolutely no evidence that he aimed or fired a weapon at officers. The Bundy family statement said, and reports appear to align with that. Officials said they believe Finicum could have planned to draw a weapon. He didn't aim. I know he didn't aim officer. He didn't aim any firearms at him. So I've seen the videos myself, and I do that in good faith. If it was the other way around, I would have been making a different view, different statement. But I'll continue on. How Ammon Bundy standoff began. The Bundys, Finicum, and numerous others started their occupation with the Mahler Wildlife Refuge near Burns, Oregon on January 2nd, 2016, following a demonstration in support of local ranchers who were convicted of arson for setting fires on federally managed land. The occupiers tore down fences, carved new roads on the reserve, and posted armed guards during their 41-day occupation. Former Idaho Statesman reporter Rocky Barker wrote at the time, Bundy at the time told reporters the activists were here to reestablish the Constitution, and some of those involved, including the Bundys, had history of advocating against federal management of public land. 3 weeks into the occupation, the Bundys and Finicum headed to John Day, Oregon, to meet with Grant County Sheriff Glenn Palmer. The Bundy family statement noted this and said their destination was not Calliston, as the FBI document alleged. The Bundys and several others in the vehicles were arrested and charged with multiple federal crimes, including conspiracy to impede federal officers. Ultimately, the Bundys and 5 others were acquitted of all charges after jurors said prosecutors failed to prove their intent. More than a dozen others involved in the standoff were convicted or pleaded guilty to federal charges. What's interesting about that, as I remember from that case, there are multiple people involved in that group who were considered FBI informants. And prosecuting attorney didn't want to present those individuals. He was trying to get that retracted, and the jury gave the big middle finger. Now we have the right to know. So I'll continue on. Bundy's statement raises questions of rogue FBI round. Ammon Bundy's brother, Ryan Bundy, was also injured in the incident. The Bundy family statement said Ryan Bundy, who was in Finicum's truck during the shooting, plans to undergo surgery to remove what they're claiming is a bullet that has remained in his arm since the incident. The statement said the government has never accounted for this round. Indeed, there has been confusion over how many shots were fired when Finicum was killed and who fired them. 2 Oregon State Police officers fired 6 shots, 3 of which hit Finicum. The agency's ballistics investigators also found a bullet strike inside Finicum's truck that could not be attributed to the officers, according to the DOJ investigation. After the shooting, investigators were able to find ammunition castings on attribute the source of 2 additional gunshots that could not be heard in videos from the scene. FBI agents initially denied firing shots or picking up casings at the scene, despite video that showed agents with flashlights searching areas where casing had been seen. The office of the Inspector General launched a criminal investigation and determined the shots had been fired from where the 2 FBI agents and the Oregon State Police officer had been standing. Esterita, whom Patel awarded the Shield of Bravery, was one of those agents. He maintained that he hadn't fired his weapon and was tried and acquitted of charges that involved making false statements and obstruction of justice in 2018. Officials still have not attributed the shot to a source. Prosecutors in Esterita's case has asked to have object to Ryan Bundy's shoulder, which they said could be a bullet fragment, a piece of Finicum's truck, or something else removed and analyzed as evidence during the agent's case, according to reporting from Oregon Public Broadcasting. The Bundy family said information about the object removed from Ryan Bundy's arm could raise more questions in the incident. They demanded the agency and Oregon State Police comply with ballistics comparisons when the object is removed to determine its source. That bullet may prove not only that the FBI agent fired shots that he did not admit, but that those hidden rounds struck Ryan himself, said the statement. The story was originally published September 7th, 2025 at 4 a.m. Correction: an earlier version of the story included an incorrect date of Finicum's death. He died on January 26, 2016. Corrected. That was corrected. Well, interesting. So, I still question these things, don't get me wrong. And they just stuck to their principles. And what happened was, they remember what happened at the Bundy Ranch in Nevada. So you can say it's a ramification of cause and effect. And according to the U.S. Constitution, federal government can only use 10 square miles of land for certain things. And sometimes it gets now it's getting a little bit too ridiculous. They own a lot more federal land, which is unconstitutional. It should be left to the states. So you have to always look at those angles. That's one of the reasons why they went over there, because what happened in Nevada, they didn't want to see it happen to anyone else. So it's called precedent. And feds don't like that. Well, too bad. I'm not, say everyone in the FBI are bad folks or anything like that, but we're going to have rogue elements in these institutions. That's why we have to exercise our natural rights, federal, state, or local. And what happened to Finicum, I still say it was unacceptable. I renounce it today, based on the footage I've witnessed. Citizen videos, and of course the Oregonian too, when they released. I question everything on this, because as far as I'm concerned, Finicum should never got shot. But here's one thing we got to look at. They've been a lot of the federal government, whether the ATF, FBI, doesn't matter. They're getting away so much, but now things are backfiring. I support downsizing and being decentralized. Too much federalization, centralization. It's extremely treacherous in our republic. They could have been a little bit done differently. Yeah, I can understand that. But you know what? They stood their ground, and those infiltrators in that particular group, FBI informants, they got caught in the trials. They got acquitted. So all you got to beware of these little gatherings, rallies, parades, protests. You always got to meet rogue elements trying to stir crap up. Doesn't matter if they're fed, the state, local. It's nothing really new. We have to learn what happened with George Floyd protests. Many of them were rioting, were busted, paid to do that. Even the rogue elements that were in J6. Handful of people were hired fools, agents, and even these big rallies from the Klan, the Nazis, all that. Don't be surprised if they're all federally funded. You always got to look at this. You want us to get triggered, so we always got to step back and see the bigger picture. Lloyd Vinicum did nothing wrong. He should never got shot. And if that's the case, based on this report, the people at the FBI are nothing more than a bunch of lying, hypocritical scumbags. I say that in good faith. But I'm not going to go after everyone who's involved, everyone who works for this particular institution. You're always going to have criminal elements. That's just how the nature of the beast is. May his soul be forever free. The Bundys, they stood there for what's right. And Thomas Jefferson said once, a little rebellion now and then is good. Well, that will be it. I thank everyone for listening. Plus, feel free to download and share us throughout your social media networks. If you have any questions, comments, recommendations, all that good stuff, whatever you do, please use decorum. You can hit me via email to ll3-podcast@protonmail.me. I will leave the footnotes of this episode on the pages. And if you want to donate, go to paypal.me or cash out at /look3. And if you want to follow me, give me a little crypto love on Steemit. I'm there at LL3-Podcast. If you want to support Reclaim the Internet, or you want to be a subscriber to Idaho Statesman, that'll be cool. Observe responsibly. Once again, thank you for your time. Please always remember that the demoniac resistance is healthy for the soul and can liberate humanity. Until next time, take care of yourselves. Keep on spreading the love, and may your guardian spirits be with you.